My name is Burkhard Hess. I'm the Executive Director of the Max Planck Institute for Procedural Law in Luxembourg. Procedural law is about the settlement of disputes. So people have disputes, they go to courts, they go to a mediator, and it's about European dispute resolution. So it's about the different court systems in the European member states. It's about the European Court of Justice, which is located here in Luxembourg. And it's about comparative procedural law, because the different procedural and court systems in Europe and also worldwide perform quite differently. There are courts where you get a judgment within 4 months' time, and there are other member states where you have to wait 2 years or even 3 years until you get your judgment. We are comparing the different adjudicative systems, and the way how to make it has changed. For a long time we looked at the different texts of the law books, and that was it. Today it's also about empirical research, about data. So the justice systems have changed in the sense that you really get information about the performances of courts, etc. So we have new tools to apply them to comparative research. And one major project of this institute was the comparative study on insolvency proceedings in Europe, together with 2 partners, one from Heidelberg and one from Vienna. We set up a network of national reporters who collected data in order to find out whether European regulation which coordinates insolvency proceedings is efficiently applied, and where are the best practices, where are the major deficiencies. And later the European lawmaker recasted the whole regulation and reformed it. Sometimes I'm asked, why do you have so many different court systems? Why is the law so different in Europe? We are constructing one car for the whole European internal market. But law is not a product. It is much more. It has much to do with history, with traditions, with language, and therefore you really need to get the whole picture, a broader view on it, and then you can nevertheless reflect to what extent harmonization might be possible. If you go worldwide, it is even more difficult to harmonize. Just take one example, the TTIP. The question, to what extent should Europe and the United States agree on a common framework for international trade? We have to be aware that in the US, judges are lay judges. You have a jury system. The percentage of cases which are decided by the court is less than 7%. In Europe, to simplify it a little bit, the average is more than 50%. These are very practical divergencies, and might also be a reason why it is good for European parties to have a framework which avoids the American court system and provides for some other dispute resolution mechanisms like arbitration. My main interest is cross-border litigation. This is a constellation where, for instance, 2 parties come from different jurisdictions, and the question is which court is competent to hear the case, and where shall a judgment given by the court be enforced. And there are many options, many possibilities. Parties can agree on a competent court. There might be a language barrier. The efficiency of the court proceedings may play a major role. The costs of the litigation might be different, and very often parties are businessmen. So for them it's really an issue to know and to be sure that they will get a judgment in due time, and that there are prospects of enforcing it. Otherwise you have a piece of paper and nothing more, and you spend a lot of money and time and effort for organizing litigation. So the idea is the Institute is following these developments, it is looking for best practices, and it is working on possible avenues for the future. We cannot directly influence lawmakers, but we can give them advice, and sometimes researchers are heard by politicians. Luxembourg is sometimes called the judicial capital of Europe, and this is true in the sense that the European Court of Justice, the highest court of the European Union, is located here, not far away from this institute. For me, it's a place to go. The neighborhood to the court is of great value. Talking to the judges, understanding how the court is functioning, also attending hearings and using the infrastructure of the court, which is a very good library. This makes Luxembourg a very attractive place. This institute is an international institute in the sense that people come from different jurisdictions. They have this spirit of being interested in foreign laws, foreign cultures, and the institute opens up a little bit the perspective of doing research, not only here in Luxembourg, but also in cooperation with partners at other European universities. I would say there are several reasons for joining it. The location is excellent for procedural law. The collaborators are international. The directors come from different jurisdictions, and the working conditions are very good. So just come and join.